Hello, my name's Richard Case. I'm here stood outside Worcester County Court, just giving you kind of the third instalment on my series on my court claim against the Ministry of Defence. Just to give you a bit of a background if you haven't watched the other videos. Yeah, I'm suing the Ministry of Defence for to try and get them to correct a factually incorrect medical assessment I just applied to become a reserve in the Royal Air Force, and they've recorded my childhood asthma as, well, seemingly as current, even though it was 30 odd years ago, and acute, and if you're not familiar with medical terminology, acute means sudden, severe and urgent, which I've never had asthma like that in my entire life. So yeah, but if you need more information, go back through and see my other videos. I go into a lot more depth on the history of the claim and what's happened so far. But this video is more about kind of my experience of how litigation works. If you're not familiar with that term, litigation basically means a private civil claim. It means you're suing someone. So it's not criminal, it's yeah, and some tips and tricks as well, because I'm a litigant, they call it a litigant in person, which means I'm not represented, I don't have a solicitor or a barrister. I've actually tried to get legal advice and no one wants to touch me with a barge pole. It seems to be that a lot of lawyers these days just stick to their own particular speciality, and I've tried to get advice from even a legal consultant, and the Citizen Advice Bureau had no joy. But stick to the end, and I'll give you my biggest tip on litigation and legal things in general, because it's the only way I've managed to get through this. But yeah, so how does it work? How does the process actually work? So the first thing you have to know, if you have a dispute with someone and you can't resolve it, my first tip would be, do your absolute best to resolve it out of court. It might be difficult. There may be your neighbour, maybe a neighbour dispute. There might be a different part of the country. You might have to do it by email or whatever. Yeah, do your absolute best to try and get it resolved out of court, because the judge will look at it favourably if you've tried to do that. And even during the court claim, keep in contact and try and resolve it, because often, I do have a lawyer friend, and he's told me that often it's best to settle out of court, potentially. If there's an amicable agreement that you can both come to, do that and cancel the claim. The court doesn't really like their time being wasted. But the first thing you have to do, and it does depend on the legislation you're going to go through, but there is always a pre-action protocol. The default one is that you should send a pre-action letter or a letter before action. I'll let you look up the details, but a letter before action has a few things that it has to have. It has to have your name and address on it. It has to have exactly what you're accusing them of, what law you're accusing them of under, how it may go to court, what you're asking them to do. Basically laying out the entire dispute, and giving them a certain amount of time to either do what you ask or respond or whatever you want them to do. It's really important you do that, which I did. I sent a letter to the Royal Air Force. As it turns out, they sent it to the wrong department and essentially lost it, but at least I did it. Once you've done that, if you're still not happy, then you, like I said, for the letter before action, you've essentially got your case sort of started, because you've laid out what legislation it is that you're claiming under, whether it's the Protection from Harassment Act or the Data Protection Act, or all the legislation is on the government site, legislation.gov.uk. But stick around because you can figure that out pretty easily. But basically, to start the claim, once you've figured, yes, I still want to go through the claim, you actually need to figure out which forms you need to fill in. So there's various different procedures. I'm just going to talk about civil procedure because it's the only one that I really know anything about. Again, I'm not an expert. This is not legal advice. It's vague guidance from someone who doesn't know better. Yeah, technically in the UK, in England at least, it's not the case in Scotland. You can actually start a civil, a criminal claim as well, a criminal prosecution. But generally you would have got the police involved before that, and the civil procedure, the CPS, the Civil Prosecution Service, the Criminal Prosecution Service would take that forward for you, and the police would get evidence and all that kind of thing. But technically you can start a criminal claim. There's a very big distinction between criminal and civil. Criminal is you basically want them to be locked up, or maybe an injunction, a restraining order or something of that nature. Whereas civil is more to do with you want money. Essentially, a lot of civil claims are about getting money back. There's a small claims court if you've got a business, and there are various different courts and things that you can go through. I'll go into that in a bit more detail. But so you need to find the legislation. You need to find the procedure that you're going to follow. So whether it's a criminal or a civil. I only know of two. I know that there's a Part 7 and a Part 8 in the civil procedure rules. Part 7 is where you basically just can't agree on facts, and it's a more complicated case because you say one thing, they say another thing, and it's up to a judge to figure out who's telling the truth, what's right, what does the evidence point to, all that kind of thing. Now I'm claiming under the Part 8 rule, which is there isn't a significant dispute of fact, because as far as I'm concerned, even though what the Ministry of Defence are trying to claim is that it is a medical opinion, and you cannot have an opinion struck from your sort of data record because it's just an opinion. However, I'm claiming that I'm the only one. The evidence that they made that opinion on came from me. I do not agree with the objective criteria that they've assessed me against. Their assessment was based on the Ministry of Defence have a huge handbook on the way they perform medical assessments. I've been through the one for asthma, and I've reassessed myself using my own knowledge of my own medical history, and it's not true. So, as far as I'm concerned, they have no evidence with which to say that they have facts that are different from my facts. So there can be no factual disagreement. My medical history is my medical history. What I said is what I said, and that's it. So I'm hoping to get it through on the Part 8, which is a lot simpler, I think. And there are different forms for the different procedures. There are different forms for everything, basically. So I think a Part 7 claim is they call it an N1 form. The form I filled in was an N. Can't actually remember the name of the form, but anyway, I'll tell you how you can find that out. You may need, if you need an interim injunction, that's another form. That's an N16A. There are forms for everything. But once you've got, with that form, you will have to submit what they call a particulars of claim. Now, you don't actually have to submit everything to the court at once. Basically, as far as I can understand, you only need to submit the claim forms to start with to actually start the claim. Now, every time you have a hearing, or when you start a claim or have a hearing, or perhaps you need a change to the claim for some reason, so you need to make what they call an application note, an application to the court, and an application for a court order. Every time you do that, you will get charged a fee by the court. Now, it does vary depending on what you ask for. It varies from about between 100 and can go up to about £400. But the way you should think of it is, every time you need a judge to do something, and they need to be involved with a court order, they need to be involved with a hearing, every time you ask for judge to do something, it's going to cost you money. And that's separate from the costs. So when you're in a civil claim, there will be costs from each side. So let's say the defendants employ a barrister. Barristers, as I've said in another video, they can cost up to, well, as far as I'm aware, they cost up to like £800 an hour. They will make submissions to the court when they have a hearing to say, hey, look, we've racked up this amount of costs. And depending on how the judgment goes, whether it goes in your favour or against you, you will be liable for at least some of those costs. So bear that in mind. When you're starting a civil claim, because it can get very expensive very quickly, and it's the one thing that is really putting me off this, because I thought what was going to be a simple claim, just to amend a single sentence on a medical record that was just essentially a misunderstanding, could turn out to be very costly if I get it wrong. Yeah. So so more about the process. So you fill out the form, you start the claim. Once you've got the claim started, you'll have a claim number. Then you can submit. You can start submitting what they call the particulars of claim. Now, from what I understand, those can vary depending on, the format of those can vary. For this particular one, because I got advised to do a witness statement, because I wanted, I actually applied for an injunction. Apparently the appropriate thing is to do a witness statement, which sets out your claim in a very particular way. Now, I don't think that really differs. I've actually done another claim for my business against another company, and that was slightly different. They called it I can't remember exactly what they called it, but essentially what you're looking to do is you're looking to set out your argument in very straightforward language, but covering absolutely everything. So covering the laws that you're claiming under, all the history of what you've done. It will be helpful to have like a separate timeline of all the correspondence you've had. But the court will, from what I understand, the court will look at it favourably if you double line that document, so that they can write their own notes in between the lines. And also, if you're good at word, make sure that each sort of paragraph is numbered, so that they can sort of refer. You can refer back to different clauses, but also they can sort of refer back if they need to. I guess when they make their judgment, they will refer back to it. So you need to submit a document called your particulars of claim. Now, when your claim gets issued, so you actually get the claim number, it's up to you to make copies of all the documents that you want to submit to the defendant yourself. So you will have to print off as many copies as you need, one for the court, one for you, and one for each defendant. And you will need to provide that to the court. Now, as far as I'm aware, they will not print it for you. You know, you actually have to submit the paperwork to the court. And the reason you do that is for them to stamp it. So it has to have a court seal. Then once it's got the court seal, they will send it back to you by post. And then it's up to you to serve those documents. So what does service mean? Service is quite an important thing. And it's important you get it right. So these days, I think most claims, I mean, again, I don't really have too much experience, but I think most claims you can actually serve by email, as long as you have sort of acceptance from, if you've got a good relationship with whoever it is you're disputing, it's probably best to get their acceptance of how you serve the document, you know, and the email address they want it served at. So you can do it by email. I've done both of mine by post, and they allow you to send it by first class Royal Mail. It's important you do that. I'd actually recommend you get it done tracked as well. So that you know that it gets delivered and when it gets delivered. So you can have no excuses that from the defendant that, hey, I didn't receive it, and all that kind of stuff. But you don't have to. But the reason you have to do it in a particular way is after you've served it, you have to fill out a service, I think it's called a service notice. Again, it's another form that you fill in. It's best, as far from what I understand, to fill out one for each defendant. Tell them exactly when you sent it and when it was received. If you send it by post, they allow two working days for it to be delivered. So you can basically just say, well, I sent it on the 20th and the service date is the 22nd. You know, but like I said, I would recommend really you get it tracked just to make sure, because one of the complications I had was one of the defendants had actually changed their address for their head office, and I sent it to the one off their website for their data protection office, and it just got bounced. The court documents got bounced around London. They did actually manage to deliver it about a week later. They managed to find the proper address for service, and I think they just sent it to their head office in the end, which was a different part of London. But at least I knew that the documents had got there. They had got there a week late, but so I sent another service letter to the court to say, hey, they got it a bit late. Then what? So once you've served it, you should get a hearing date through. Again, you'll probably get it by letter, and they'll send it to both you and the defendants, saying what the hearing date is. Now, what is a hearing? That's an interesting question, because there are various different types of hearing from what I understand. You know, I was expecting, hey, you just turn up, you tell them what the court case is about, they make a judgment, you go away. It's not the case. The first hearing I've had in this instance was essentially what they call a directions hearing, which is if there's any sort of problem with the claim itself. So, you know, in my instance, I'd claimed from the wrong people. You know, I had the wrong names on the claim essentially. They will say, you know, okay, we'll have a directions hearing to figure out what needs to happen next in this claim. And from that, they will issue a court order to make whatever changes is needed. You know, maybe it's an adjournment for however long, or whatever. So, and again, you know, even if that hearing is a directions hearing, that will cost you. So if there's another hearing, you're going to have to pay again to have that another hearing. Yeah, so a directions hearing is basically just a hearing with the judge to figure out what needs to happen next. There is a final hearing, which is the actual trial itself. I think the terminology differs depending on whether it's criminal or civil, but that is where you actually have to argue your case in front of the judge with the defendant. So the judge will typically, as far as I'm aware, come to the claimant first. You'll lay out your entire argument, which is already documented. You know, they've got it in paper form. They've got it in paper form. I'll come to evidence because that's an important point. They'll have it in paper form, but again, from my experience, don't expect them to have read it. The judge may not have even read any of your paperwork I guess by the final hearing, they will have read it, but in both times that I've been to court, they haven't, or had a hearing, they haven't even looked at the paperwork before the hearing. So, yeah, the evidence. So, I was a bit confused as to how much I needed to actually send to the court with the claim. So I think as far as I'm aware, you only need to start the claim with the claim form and get the claim number. You don't need to actually submit any argument or anything at that point. But you will have to provide it eventually. So you need to put together all the paperwork and provide your sort of skeleton argument. I think it's got various different names depending on who does it and what kind of claim you're doing. A statement of case, I think it was, or in another claim, or a barrister will submit a skeleton argument, or it could be a witness statement. But basically, by the final hearing, you need to have submitted all your entire argument, plus all the evidence. They call it a court bundle. So, and that, again, that needs to be structured in a particular way. So people have told me that you need to have like an index of all the documentation you're providing, including all the evidence. You need to provide a timeline of what's happened, from the very start of the dispute. And it all needs to be organised and numbered so that you can refer to each piece of evidence in the actual final hearing itself and talk the judge through every single piece of evidence, laying out exactly how it applies to the legislation and your particular dispute and claim. But this could take a while, It's not a simple. You issue a claim for, you get a hearing, you argue your case, that's it, done. This could take months. You need to make sure that you've issued all the documentation, to every party yourself, and that they've received it supposedly in plenty of time. I mean, that's another weird thing with this. There doesn't seem to be any statutory time scale for having received the documents before the hearing. I mean, in this claim, I received one skeleton argument from the barrister literally 4 hours before the hearing. From the other barrister, I didn't even receive a copy till after the hearing, and the judge still admitted it admitted it into the claim, which, as far as I'm aware, is not correct. But I would allow at least a week's time before the hearing, or if you've got a date set to serve the documents on the defendants and all that kind of stuff. I guess they could just claim, I didn't receive it in time, let's adjourn it for another time, and again, that's going to cost you another hearing. I don't know whether that's highly possible. Again, it's up to the judge to decide under the civil procedure rules, what is fair and what is reasonable. So if they decide that it's unreasonable for the defendants to only have had the documents for, say, 2 days or 4 hours or whatever, then that's that. But again, I guess what makes it complicated is you have to, on the day in the hearing, you have to be confident enough and know the rules enough to know what's acceptable and what's not acceptable, and make your argument. So even down to the civil procedure rules. Because if you don't, the way it seems to work is if you don't argue it, the judge won't argue it for you, is the way it appears to work. The judge is literally there to sit back, listen to everything, make notes, and at the end of the hearing, once they've been through that procedure, make a decision, and explain exactly why they're making that decision. So, solicitors and barristers. So I made some notes here. This is getting quite long now, so I'll try and wrap it up. Yeah, try and get legal advice if you can find one. I've tried getting a solicitor. I've tried asking barristers. They don't even want to give me a quote a lot of the time. The town that I'm from, they don't even have a litigator, they call them. So none of the solicitors do litigation in the town that I'm from. It seems to be a dying art. It seems, people just don't want to do it these days. But try and get legal advice, but again, you may not even be able to find any. So we touched on the different courts. Like I said, even in the civil world, criminal and civil are very different. Behind me is a combined court, which is a Crown Court and a County Court. County Court is civil, Crown Court is criminal. Down the road there is a Magistrates Court. Now again, that's a criminal court, but it's kind of the lowest level criminal court. The judge, I found this out, is actually not paid. They're a volunteer judge in a Magistrates Court, but as such, they only have limited powers. So they can only make custodial sentences, I think, up to 6 months, and anything that is at risk of going over that, they'll transfer it to the county, to the Crown Court behind me. And then there's like High Courts and Supreme Courts and I don't know, the Old Bailey and all sorts of different courts. They all do different things, and there's different courts within different courts too. So in my business, I made a court to the Intellectual Property Rights Court, which is part of like the business courts, which, there's a whole heap of different courts, and it's one of the things you need to look into if you're making a claim as to exactly which court you should even go to. They all have different facilities, some will be electronic, some won't, some will let you email in, some won't, some will have a phone number, some won't. They'll be in different parts of the country. The fees are somewhat similar. They have different fee structures depending on what you're actually asking for. But again, another thing you need to look into. But I'll come up with a big tip at the end. We've been through forms, we've been through service and submissions. Like I said, don't forget to send the service form to the court, because the court won't help you with this. The court expect you to know exactly what the procedure is, and send them all the correct forms and all that kind of thing. If you missed things out, like if you forgot to sign something, or you've missed out a box and you need to fill it in, then they will generally tell you that kind of thing. But in terms of what you need to submit, that's you know, that's up to you to find out. Like I said, some courts will have electronic filing, some won't. The small claims court, yeah, if it's, I think the small claims goes up to £10,000. That's the most obvious route for most people. Like if it's a money claim, if you've got, you know, you've issued an invoice and you just haven't been paid, you've got evidence you've done the work and it was all agreed and everything like that, and it's just and you just need to claim that money back. A small claim goes up to £10,000, and they have a very prescriptive electronic form online. I think it's moneyclaims.co.uk or something like that. Something like that. They got a special website. So some processes are very prescriptive, and they tell you exactly what you need to do to make it simpler. Some are, you know, completely open. The other one I do know about is when you're trying to evict someone. If you've got a rented property and you're trying to evict them, there are some very specific rules you have to go through even before you get to the claim. Like the pre-action protocol, I think they call it, is you have to have served them, you have to have given them certain like government documents on short hold tenancy agreements and all this sort of stuff, and you have to have taken a deposit, and if you haven't squared it all that away, the court is going to not really look at you very favourably. They're going to take that into account, and you're going to be screwed. So do all that first. Make sure you've done all that, and do it to, even if you've not done it, you need to do it to the best of your ability before you even start doing the claim. In court, we've been through costs. So the only other thing I'll say on court is, which I touched on in another video, is the courts are very different. Like, I'd actually recommend you go to a court like this. So a Crown Court, which does criminal prosecutions. I'm not sure about a magistrate, so I assume they're the same. But because criminal prosecutions are sort of public, because it's a matter of public interest, they have a public gallery, and that can be an interesting thing to go and look at if you're interested. Because here they have two courts that you can go into, which just have a public gallery. They do have like a security gate that you have to go through, like with a metal detector first. So, but once you're in there, you can just go up to the gallery. The cases seem to go from 10 a.m. until 1 p.m. They have a break for lunch from 1 till 2, and then 2 till about 5. And you could just go in, as long as you're quiet. You're not allowed to record, you're not allowed to eat, you're not allowed to take phone calls or anything like that, but you could just sit there and watch what happens. And it's kind of interesting. You'll see here they have two courts. They're fairly big. They're suitable for juries. They won't always have a jury, but because there are various different sentences in the criminal system as well. So they'll have like the actual trial with the jury, or it might just be a sentencing hearing, or with very few people, just like the judge and the defendant. So all the hearings are quite different, can be quite different, but it's worth having a look, because I think the general principle between civil and criminal are, pretty similar. They have, in terms of fairness and the general letting both parties have their say, and presenting things in a non-emotional kind of factual kind of way, and making sure everyone's got all the evidence and all that kind of stuff, making sure it's fair and reasonable. I think they're both pretty similar between the two procedures. It's just the level of evidence is different between the two, and whether you have a jury or not, and whether it's public or not, and the different statutes and that kind of thing, they're different. But finally, I will come to my big tip on if you're a litigant in person and you really need some advice, you perhaps don't have the money to do it. ChatGPT. If you've never heard of it, artificial intelligence. There are various different ones out there. ChatGPT is done by a company called OpenAI. You need to be a bit careful of the different apps that are available, because there are some sort of ones. It can be quite complicated to figure out which is the specific app that you need, because some artificial intelligent apps have a very similar name and they use the OpenAI service on the background, so it's sort of very similar, but then they actually charge their own fees. I'd recommend, I'm pretty sure the website is openai.com. If you go there, there will be links to chat. It's called ChatGPT. I can't remember what it stands for, general purpose something or other. But that seems to be the best one I found. Google and I think AWS and Apple and I can't think of any other companies. I think they're the main ones. They all have their own systems, whereas ChatGPT seems to be the best one that I've used. The other ones didn't seem to be. Oh, and Grok from X, that's another one. Yeah, ChatGPT seems very, very good. My tips would be very specific. Like, it's not 100% accurate. It's definitely not, because I also use it in my job as a software engineer, and I've found that it can lie. It's sort of, I would say, it's sort of 85% accurate, but it's also very confident in its lies. You know, it doesn't lie on purpose. It just sort of doesn't tell you the whole truth. And you have to ask it very specific questions, and sometimes you may have to correct it and just say, look, you said this, I've done my own research, and actually it's this. What went on? And it will say, oh yeah, you're right, it is that. So you need to be a bit careful, but because law has been around for a while and there's a lot of things online on different forums and on the government sites themselves, it is actually pretty accurate, I would say. Certainly in helping you with the procedure. You know, if you don't think something's right, it was very helpful in figuring out which civil procedure rules that didn't seem to be right according to what had happened, and telling me exactly which procedure rules, you know, I should look at, and all that kind of thing. But you do need to ask it very specific questions. You know, here's my claim. You know, this is what I want to dispute. And I'm in the UK. What are the forms I need to fill in to start this claim? What is the format of the evidence I need to give, or the written documents I need to give if I'm litigant in person and I'm claiming under this law? You know, be as prescriptive as you can, but you can also give it things to correct, you know, and check for grammar. You can paste in an awful lot of information in there. You could paste in your whole document and just say, hey, can I make this more suitable for use as a submission to a court? And it will go through and it will just rewrite it for you if you want it to. Or you can ask it, just say, hey, I don't want you to rewrite it, but please could you give me tips on how I can make this better? It will do that. It will, the sort of the volume of information you give it, you can also tell it that. It tends to be quite verbose generally, but if you just want a quick answer, you can also tell it that. Just say, hey, give me a very brief table of what you can see wrong with this document according to, you know, this claim and against these rules and this sort of thing. Yeah, but I found it invaluable. I mean, I haven't finished my claim. These could be famous last words. Almost literally, if it all goes wrong. Yeah. So, but that would be my biggest tip. ChatGPT. You can get it on your desktop, in your web browser, and you have to create an account. You log in, and it actually keeps a record of all your previous questions that you've asked it, and both what you put in and what it responded back to. It's like having a conversation, and it just keeps them forever. So you can always refer back to them, which is very useful in a court court claim. If you've had a conversation, then you think a week later, oh, what did it say about that again? I'm sure it quoted some civil procedure rule. You can go back and have a look. And you can also download it as an app on your phone. And it's a shared login, so whatever you put on your desktop is also available on your phone. It's the way things are going. I wouldn't be surprised. These are my predictions in the next 2 years. The legal profession just won't exist. I mean, the courts will exist, but in my experience, the accuracy of artificial intelligence now and what it will be in 2 years' time, I just don't think solicitors and barristers will have a job. I just can't see it. It's just so good, and I think people will invent apps that concentrate on specific areas of life, legislation and law and that kind of thing, and so even engineering, maybe there will be specific software engineering apps that focus specifically on different languages and design software. So there might be a lot of us out of a job in the next couple of years. Really, it's June 2025 now. Right, I've rabbited on for long enough. I hope that has been useful. I will try and provide more updates and tips and tricks for litigants in person, and keep you in touch with how my court case is going. I'd be interested to hear what you think. Please be gentle. Like I said, I think I've got a claim. I think I'm justified in asking for my medical record to be corrected. You might think it's trivial, and I might just be wasting the court's time and this kind of thing. But and to be honest, the hassle I've been through with this claim, I may well think twice about continuing with my application to the Royal Air Force to join as a reserve, because if this is the way I get treated as a British citizen who just wants to help their own Royal Armed Forces, their own armed forces out, then maybe I really should think twice. Maybe Britain has become that bad that they are simply beyond help. They are simply beyond help. And you'll have seen the people who infiltrated Brize Norton, RAF Brize Norton. As I put in an email recently, I could have been the one on the patrolling the border that night. I'm a reserve. It's the sort of thing they get reserves to do, is to be on duty when real, the real employees have better things to be doing. I could have stopped that, and we're now paying, from an article I saw, somewhere between 30 and 50 million pounds worth of damage for them getting into Brize Norton, which I could have stopped. But instead, I'm fighting the Ministry of Defence on my claim, which could cost me potentially my house, and that's where we are. So, thanks for listening. If you've got this far, like and subscribe if you want more updates.